Hi, Amanda.
Hi, Josh. We're talking about one of my favorite topics today. What is it?
We're talking about basketball, and it's basketball and employment law. As we sit here today recording, we're in the middle of the NBA playoffs. It's very exciting for basketball fans like you. I gotta admit, I'm not a follower of professional basketball, but go Huskies. There's something going on with the NBA and employment law and Tyrese Haliburton, a person you just told me about. So tell us what's going on and what our viewers can know about the employment law implications of this situation.
I love when my worlds just connect here. So this is fun. Big basketball fans in our house. I won't tell you which team we root for, but honestly, we watch just about every NBA game that is on. And of course, that includes the playoffs. So the first round of the NBA playoffs in 2025, the Indiana Pacers defeat the Milwaukee Bucks 4-1. At the end of that game five, Tyrese Haliburton, who is a guard for the Pacers, he was on Team USA, won the gold medal for the United States in the last year's Olympics in Paris. His dad, who is a fan and a spectator, rushes the court and he gets into Giannis Antetokounmpo's face, and he's really bolstering. He's projecting this win, and he's very excited. But these two guys end up going forehead to forehead in what became a very, very, very tense exchange. You didn't know if punches were going to be thrown. It was pretty interesting to watch. Well, why does this matter for employment law? After this exchange, the NBA decided that they were going to take some action, and they banned Tyrese Haliburton's dad from going to Indiana Pacers games. He wasn't allowed to be there. And there was some outrage. Just this past week, we heard Charles Barkley saying to Tyrese Haliburton after a win, free pops, free pops, let's get your dad back to games. And effective just this weekend, while we're in the midst of the conference finals, the Indiana Pacers have said Tyrese Haliburton's dad can come back. He needs to be in a suite for home games. So the question is, why did they do this? Josh, talk to us a little bit about why an employer of someone like Giannis Antetokounmpo would take this type of action to protect him while he's at his job as a player of the Milwaukee Bucks.
Well, employers are often on the hook, Amanda, if their employees are in dangerous situations and they know about it and they can prevent it. So they might be liable if they fail to do so. In this context, let's imagine that Tyrese Halliburton's dad had come back to a game, he hadn't been banned from games, and then he got violent with another fan, right? If that fan had been hurt, might they have sued the NBA and said, NBA, you have not taken appropriate actions to make me safe here. You were negligent. This comes up in the employment context a lot in the case of sexual harassment. So an employer is not liable for sexual harassment generally if it is committed by a coworker or a third party, that is someone who doesn't work for the company, and they have no notice of it. They took appropriate action to prevent it, but they didn't have any specific notice of what that coworker or third party was doing. But once the employer knows that a coworker or third party is a threat for sexual harassment, it's demonstrated themselves to engage in sexual harassment, the employer has an obligation to do something to prevent that sexual harassment. So we see this a lot, Amanda, in the context of restaurants, of retail establishments, where there might be a customer or a patron who really does not treat the employees well or respectfully. They might touch the employees inappropriately. And once the employee goes to management and says, hey, Joe customer is sexually harassing me, do something about it, the employer needs to do something about it. And if the employer does not take affirmative steps to prevent that sexual harassment, and Joe customer comes back and commits a sexual harassment again, now the employer is arguably liable for that sexual harassment under our anti-discrimination laws, both state and federal. So this idea of notice to an employer's obligation to prevent unlawful and dangerous conduct, including sexual harassment, is something that comes up in the NBA, but it also comes up in our everyday practices here in Connecticut.
This is the first thing we need to prove in these types of cases, notice. And once we can, then liability can attach. So really what the Indiana Pacers organization was doing, what the NBA was doing, is they were protecting themselves legally so that if this happened again, they could say, hey, we were on notice of it, but we did something to prevent it from happening to someone else. So liability shouldn't attach. Interesting intersection of NBA basketball and employment law. Thanks for watching. Take care.